Welcome to this video clip. I'm Cheung, a partner of the Construction and Arbitration Practice Group in Deacons. This is our first short video clip on construction law. Today's topic is construction adjudication. The traditional means for resolving disputes in Hong Kong is litigation in court or arbitration or mediation. Adjudication used to be not so common in Hong Kong, but that may change in the near future as people find the traditional means of dispute resolution not so cost-effective. After the implementation of the Development Bureau's circular on security of payment, usually called SOP, for tenders for public works in 2022, adjudication may become more popular. So, what is adjudication? Adjudication can take many forms. For the present purposes, I just want to borrow the description from the Hong Kong International Arbitration Center, HKIAC. It is described as adjudication is a simple, effective, and swift method of resolving disputes. Adjudications are conducted by a sole adjudicator in accordance with the rules and terms of the contract and its applicable law. Adjudicators make decisions which are binding on the parties. In most cases, the decision of an adjudicator can be revised in another forum, such as arbitration. Adjudication is common in construction disputes. Here, I will briefly explain the procedures for doing adjudication based on the HKIAC adjudication rules. Adjudication is commenced by a party to the contract with a written request to the other party and the HKIAC to refer to adjudication and any disputes arising under the contract. The request for adjudication shall contain a concise statement of the nature and background of the dispute and the remedy sought. At the same time as the referring party serves the request for adjudication, it shall also serve on the responding party and the HKIAC a list of nominees of at least 3 names of nominees for adjudicator. The responding party should similarly do so. Then the parties should try to agree on the appointment of adjudicator within 14 days of the request for adjudication, failing which the HKIAC will appoint the adjudicator for the party in accordance with the rules. The HKIAC has a panel of adjudicators from which the parties may choose their adjudicator. Within 7 days of the written confirmation of the appointment of the adjudicator, the referring party shall serve its written referral submissions, containing concise submissions in relation to the dispute and all documents which have important and direct bearing on the issues. Within 7 days of the receipt of the referral submissions, the responding party shall similarly serve its response submissions. The adjudicator has widest discretion to decide on the procedure to be adopted in conducting the adjudication. He or she can call an oral hearing and call witness. The adjudicator should then make a decision within 56 days of the referral submissions. What are the characteristics of adjudication comparing with litigation and arbitration? Here is a simple comparison. In this table, you will note that the adjudicator usually has some construction background. It is the quickest and also the cheapest. It is temporarily binding on the parties. It means that the winning party can enforce the adjudicator's decision in court. So adjudication provides a quick resolution of disputes arising during the currency of the project. Any review of the decision is usually only done after the completion of the project. According to the experience in the UK, many parties won't go further after adjudication for practical reasons. In our next video clip, my partner, Cheung, will talk on the security of payment provisions for public works contracts, and perhaps he may also say a little more about adjudication under the SOP. Goodbye.